Members, the House and Committee on the Sentencing Aggravated Factors Amendment Bill. The question is that Clause 1 stand part. Call Charles Chevelle.
Thank you, Mr Chairman. Mr Chairman, just to explain to colleagues what we are doing here, there's a bill before the House in the name of the Minister and the Chair entitled the Sentencing Aggravating Factors Amendment Bill. And the purpose of the bill is to ensure that the fact that an offence committed against a police officer or prison officer acting in the course of his or her duty is taken into account as an aggravating factor at sentencing. So when this proposal was considered by the Labour opposition, we thought that it was a sensible provision. We are fully supportive of ensuring that police officers or prison officers in the course of their duty have the maximum protection that can be provided by the law. We accept the case that there has been an increase in risk against both professions by reason of them having suffered greater threats and actual violence in the course of their duties. Those duties are important.
I'm sorry to interrupt the member. Clause 1 is, because we're doing clause by clause and not part by part, Clause 1's actually the title. And while it's interesting what the member's saying, there was a way around this which would allow you to continue, but it's up to the Minister or a government member to move that the clauses be taken as one question. That's point of order. The Honourable, you have to seek leave here. The Honourable Judith Collins.
Mr Chair, I seek leave of the House for this matter to be taken as one question so we can have a wide-ranging debate.
So leave is sought for the debate to be clauses, the debate to be on clauses 1 to 5. So the question is that clauses 1 to 5 stand part, and I'll invite Charles Chevelle to continue. Oh, is there any objection? There is no objection. I'll allow the member to start from his 5 minutes starting now.
Thank you very much, Mr Chair, and I know that my colleagues will be very happy about that. And I'm very grateful that the House moved the leave that it did, or accepted the leave application from the Minister, because how we would have heard any sensible speeches on a clause that provides this Act as the Sentencing Aggravating Factors Amendment Act 2010 is a question that's probably not worth pondering.
Done it before.
The member next to me says she's done it before. That was clearly in the bad old days. Sir, as I was saying, the original purpose of the bill was to provide that it would be expressly a duty on the court in sentencing somebody who assaulted a police officer or prison officer in the course of their duties to regard that assault as an aggravating, to regard the occupation of the person who suffered the assault as an aggravating factor. And as I said, we were fully supportive of the policy intent behind that, but we were concerned that there were other professions who, like police officers and prison officers, had no choice in the course of their duties but to put themselves in harm's way. And it didn't seem logical to us that members of those professions shouldn't receive the fullest protection of the law as well. And that is why the supplementary order paper number 14 in my name would provide that emergency health or fire services providers acting in the course of their duty at the scene of an emergency would also, if assaulted, have the fact of their professions and the fact that they were carrying out those duties when they were assaulted regarded as aggravating factors in the event that the matter came to trial and sentencing. I want to acknowledge the Minister for her cooperative approach when I first put the suggestion to her. We did have some toing and froing about the exact wording of the supplementary order paper, but in the end the principle was agreed, and so my understanding is that that supplementary order paper, along with the Principal Act, will receive support at least from the two major parties and one or two other parties who've written to me to express support for the approach in my supplementary order paper. The acting leader of the House's instruction moved by leave also applies to a supplementary order paper in the name of Asanati Lole Taylor. That supplementary order paper would also make it an aggravating factor in sentencing to take into account the fact that the assault occurred against a corrections officer conducting enforcement duties, which would be defined as the exercise of any statutory enforcement power, and for the purposes of the Corrections Act 2004 includes performing non-custodial services. Sir, I don't know what the position of the government is concerning that particular supplementary order paper, but I can signal that the Labour opposition will give that supplementary order paper its support on a substantive basis. So, sir, to summarise, as far as the position on this side of the House is concerned, yes, we agree that prison officers and the police do deserve the fullest protection of the law. If it can be afforded to them through making it an aggravating factor at sentencing, that is, magnifying the effect in law of the sentence because of the identity of the person assaulted, then that should happen. But it should also happen to fire service responders and to emergency medical responders who are in a similar position in accident scenes. And it seems to us that the extension in respect of prison officers that is moved by Asanati Lole Taylor is logical as well, because again you have people who put themselves through their job, through no choice of their own, into the path of danger in order to preserve and protect the public safety, and we ought to support everybody in that position, Mr. Chair.
I call Jackie Dean.
Thank you, Mr. Chair. The Sentencing Aggravating Factors Amendment